All right, so we are recording now. This is the September 22nd meeting of the Post-Conviction Relief Standards Work Group. I am going to pick up exactly where we left off last time around. I will share that screen. And last time we were talking about the difficulty in getting files in Ramos and other older cases with retired counsel, and the duty to conduct an independent investigation. Do we want to add anything to the note on the difficulty getting older files? Ed, right now it says, oh, go ahead.
I was just, for background for Ginger, I think I don't know that we need to include this, Ginger, but it was just sort of the question of, okay, how far do you have to go, or how far should you go in some of these cases, whether it's even something we need to include. I think we all agreed that your opinion and deference would answer a lot of questions, but we were just kind of brainstorming, like, do we include that, and how far maybe go? Like, I have an out-of-state counsel. I don't think I'm going to subpoena in the foreign jurisdiction over a file, but there's some unique circumstances. So that was just kind of context, Ginger. Thanks.
Thanks, Ed.
Okay, so have we done 1 through 7 and we're just looking at 7 now, or are we looking at this whole independent investigation thing?
We have discussed 1 through 7. We left off last time discussing 7. Your thoughts and comments on any of that 1 through 7 are perfectly welcome.
Okay, so 2 is wrong. The victim's rights do apply. They apply in any, collateral. That's my understanding. And so in terms of the independent investigation, the victim's piece, and this is just more for information, I don't know what we need to put in there, but I mean, the investigator has to go with a victim's rights letter.
Mm-hmm.
And then there's a specific provision in the post-conviction statute that talks about, what you're allowed to do essentially with a victim. I mean, it's one thing if the court, it's one thing if the victim will voluntarily talk to you, but if the victim or alleged victim won't talk to you, you can't just subpoena them. You have to get a court order to do that. And so I would maybe just put in the post-conviction statute that talks about what you have to do in order to depose. I think the statute is even to depose them, you have to get a court order. And in my experience, the definition for victim is larger than just the actual victim in the case. I've had the the Attorney General's office assert that, the parent of a child victim is also a victim.
Mm-hmm.
So,
the term victim is defined somewhere in the victim's rights statutes.
Yeah. So at any rate, I would definitely have them be aware of that statute. And then for one,
the
subpoena.
PCR statute says, it says to issue a subpoena. So typically that would cover deposition trial. I suppose a victim could agree to deposition without a subpoena, but that's how it references it. So.
Okay. And do you have the statute in front of you? Probably.
I don't. I have it on my desk, but I'm not at my desk. Sorry.
Okay, I don't have it either, but it's right in chapter 138. And so then the number 1 subpoena power and depositions.
Go ahead. Sorry, would you like me to pull the statute up?
I think it might be good just to put it in there.
Sure. Give me 1 second to find it then.
And then we don't have to maybe interpret the statute. We can just have the statute there for people to look at.
Like it's 138627. Got it. All right. Subpoena power and depositions, use of discovery tools.
Yeah,
Ginger.
I was just thinking maybe that's, I mean, because you can do a request for production of documents, request for witness information. So I don't know if we want to spell out which discovery tools or not.
Might as well have them in the notes, then we can decide what to include
Okay.
when we go to drafting.
Okay.
Request for documents,
witness
request for
information.
anything else?
I think those are the big ones. Oh, and there is a specific discovery statute. What is it? So it's a little bit different than the UTCRs in the sense that I don't think this applies, but I just got into this discussion. So in a normal civil case, you don't have the duty to disclose witnesses, but in a post-conviction, you have to disclose within 60 days of trial. And the state has been successful in excluding witnesses when you don't disclose after 60 days. So I don't know that that's pertinent to the independent investigation.
Well, it's
Probably a
Or
good
just-
60
note to
days
have in there somewhere.
if requested, right? Which they always do. They
No,
always
it's in the
request.
statute. You have to turn it over earlier if they request it earlier.
Okay.
Well, I've got into that fight with them. They have requested it early and I turned it over 60 days prior to trial, and the court gave them the motion to continue because they basically said that I needed to disclose earlier. That is a fight I'm going to have at some point, but not right now. I think the 60 days controls, but at any rate. But it's not just they must disclose witnesses 60 days. It's not prior to 60 days. It can be on the 60th day. Yeah.
Got it.
Okay. Um, so in terms of number 3, do you want to like spell out if they need a mitigator, then it needs to be a mitigator, not just an investigator?
I think we talked about, I mean, yes, we do. I think we talked about including some language on working with other experts also.
Okay.
I
Oh,
don't know
somewhere
where
else.
that got.
Okay.
I don't know where that got stuck. And full disclosure, working on like 3 of these, so
Yeah.
it may be in a different standards group.
So I'll tell you what I get in every case and then, sorry.
Oh, go for it.
So in every case, I get the trial counsel file, the DA file, all law enforcement files, appellate attorney files, the trial court file, and the appellate court file. So I don't know if we want to add in the law enforcement file. And then I also get all CARES reports, all of those different types of child reporting agency files. And for that, I mean, the practitioner needs to be really familiar with stipulated protective orders.
Mm-hmm.
And that's both for, and we can talk about where to put this, but when you get trial counsel file, and then you get a request for production of documents with trial counsel's file, or for trial counsel or appellate counsel's file, then those documents need to be protected. I mean, your client has waived, I call it a limited waiver of the attorney-client privilege, but it's just for the post-conviction. And so we really want to avoid the AG's office. We want to avoid them being able to turn over trial counsel's file to the DA's office if there's a retrial. So anytime we get a request for production of documents for trial counsel's file, we always have them enter into protective order, and then we protect any deposition or testimony from trial counsel. Yeah.
Great.
Okay.
All right. How are 5 and 6 before we get back to 7?
Five and six look good. I mean, I include investigators in that as well for 5.
Okay.
Yeah, I mean, I don't know what else to say about 7. You can always sometimes, if they're disbarred, they should be turning their file over to the bar.
Mm-hmm.
We run into this a lot, and we just we just look everywhere we possibly can, or try and reconstruct trial counsel's file through the investigator's file, but a lot of times that doesn't work. I would just,
Okay.
I think it's just important to document what you've done. Oh, and I know a file that you should be requesting is the
What's that?
OPDC file, the OPDC file.
Sure why my computer decided that should be in bold, but
Yeah, well, let me just look up my thing and see if there's anything that I left out.
yeah. So I think with the getting case files from older cases, the understanding I'm getting from you all is that what we're really talking about is, there's I don't know if cost benefits analysis is the best term for it, but there's a breaking point where the effort you're putting into getting older files isn't worth it. But you should always have documentation of why you reached that point and what you did to reach that point.
That's not what I do. We basically look for it until we can determine that it's not available.
Mm-hmm.
We don't really ever do a cost benefit analysis. Yeah, at some point you're going to reach the end. I understand with I mean, it's hard because with Ramos cases, I mean, sometimes, in my opinion, that analysis goes into the strength of the evidence. So but I understand the thought process behind Ramos, but are we even going to be getting any Ramos cases anymore? I mean, that statute has run. I think that they had to file, I think that there was a filing deadline. I suppose some people may try and get him in based on the escape clause.
Mm-hmm.
But at any rate, that's hard to answer.
Okay.
I just look for it until I can't look for it anymore.
Got it. Okay. Anything else on the conduct an independent investigation prong? Do we need an 8?
No, I don't think. Keep scrolling down. I was just gonna look at a file really quick to see what my file. Okay, appellate counsel, appellate court, medical records. I have a separate file for that. ODOC records if applicable. So I would say medical records if applicable, ODOC records if applicable.
What kind of medical records are you looking for? That are
so
they
in
things
this
that would have been
in this
post-trial
part,
or?
well, so medical records if somebody has like a pre-existing mental health issue. So these are the file I'm looking at. Yeah, it's all mental health medical records. And then
And is this stuff that would have existed at the time of trial?
yeah. Yeah. I mean, obviously the ODOC records, that's yes, if they were ever incarcerated before, but sometimes we use ODOC medical records if, so you can show that the mental health issue was ongoing or like it still exists. The one thing I was gonna say. Yeah, I think that's what I have in my files.
Okay. Great. Ed, anything you want to add to any of that?
No, without being able to see it, but it sounds like Ginger was looking at everything included, and certainly she's touching on all the topics. Thanks.
Okay. So our next big section, and we have not talked about this one yet, is the asserting legal claims section.
I actually just thought of one other.
What's
So
that?
if there's a co-defendant or like a snitch, then we get their files as well. So like if there's a snitch, one thing that's really important is we get the DA's file for the snitch, and if there's a federal AUSA file. Okay.
Okay. Okay, so the
Shoot.
asserting,
I just thought of one more thing.
what's that?
Sometimes we get the jail file,
Mm-hmm.
if there's a medical jail file, if that's applicable, and sometimes the visiting log from the jail. I think that's it. When Sean asked me to write the investigator's manual for post-conviction, and I was like, you just get everything. Like, what else? You don't need to know anything. You just get everything. So that's
get everything you can think of. Think
that's why
harder.
I just
Get
keep
that.
adding things. Yeah.
No worries. We can can add or subtract
Okay.
to this as we go. Then once we turn it into actually like formatted documents, we can go through it again and make sure we have everything we need.
Okay.
So living, breathing documents. And even then, I suppose in a year we'll be looking at them again to make sure we didn't forget anything or
Yeah.
accidentally mess anything up. So the next section, we've got the asserting legal claims section, and we are pulling these from the Oregon State Bar performance standards from way back when. Says counsel should be familiar with all legal claims potentially available in post-conviction relief proceedings and assert claims permitted by the facts and circumstances of a petitioner's case so as to protect the client's rights against later contentions that the claims have been waived, defaulted, not exhausted, or otherwise forfeited. Anything we want to kind of add, change, amend to that, or things that folks should do along those lines, or in addition to, I suppose.
I would just add in that they need to be familiar with the Church v. Gladden.
We've got a whole section on
You do?
church
Okay.
motions already,
Okay.
which we should. Is it Gladden? Gladen?
I think it has with 2 Ds.
So we should actually put the case name in that section.
Yeah, so maybe just I don't know, reference that section.
Mm-hmm. Okay.
Do you want to put anything in there that you can ask to amend the petition, and those are normally liberally granted?
Mm-hmm. What kind of things are you looking for when you're looking to amend the petitions?
It's really case dependent. Um, a lot of times we'll draft the petition, our clients won't have the opportunity to review it beforehand, and so then in order to avoid, like, if there's absolutely any merit to it, then we'll amend to add their claim. I think
Mm-hmm.
amendments happen most often when you don't have all of the files before you file the amended petition. What's been happening more and more, and maybe this is more of a practitioner's notes, my petitions are extremely detailed, which we may move away from that for this reason. If, say, for example, we just had this come up, our main claim was that trial counsel failed to object during closing arguments. And then we had
Mm-hmm.
like 5 quotes from the closing argument. And then in our trial memo, in addition to those 5 quotes, we put 5 more in, for example. And so the Attorney General's office moved against those 5 additional quotes, claiming that we didn't, you know, we didn't properly plead those quotes in the petition. I think that we would have won that on appeal, because that's not, I mean, it's all about notice, right? And they had um, notice that we were arguing about the closing argument. Talked to appellate counsel said, you're fine to go forward. They will lose on that issue. This is properly pled.
Mm-hmm.
But we decided not to roll the dice. Because what if we're wrong? What if the appellate counsel is wrong? So we amended to include those additional statements.
Okay.
So sometimes we amend just to shore up, what we
Mhm.
actually end up pleading.
So can I back you up a little bit before
Yes.
that? So my understanding of the PCR process, and please keep in mind that my understanding is
Yeah.
probably not great, like maybe a little less than surface level. Um, a person who thinks they have PCR issues files a petition for PCR themselves. It goes to the court. The court decides whether or not to appoint an attorney. If they appoint an attorney, you have the ability to amend the initial filings right away. And then you're saying that as you go on, you may find other reasons to amend later on. Is that at least close?
That's right. I mean, the court doesn't have the, they don't, in my experience, they don't get to pick and choose who gets an attorney. If you file a post-conviction, you get an attorney.
Okay.
And then, you get the attorney by filing a pro se petition.
Mm-hmm.
And then after the pro se petition is filed, again, you get an attorney, and then the attorney files the formal petition. And then the attorney can move to amend the formal petition. And so the next filing would actually be the first amended petition after the formal
Okay.
petition.
So when we're talking about you've got 180 days, that would be the formal petition.
That's for, yeah.
Okay.
And I mean, sometimes petitions I've seen like seventh and eighth amended petitions.
Okay.
So, well, I mean, it's like I said, it's very liberally granted. I think the only way they can deny amending a petition is if the defendant superintendent can, well, for good cause. And, essentially, if you've been working on the case, then it's good cause to amend. The defendant superintendent has tried to argue that, they would somehow be prejudiced, but there's just never prejudice when we want to amend the petition. So,
Mm-hmm.
anyways, long story short, they're liberally granted.
Keep it in mind, like it has to be timely. I've never moved to amend at trial or really close, but I think that would be their best argument against it is how close you are to trial. For me,
Yeah,
I
I've moved at trial. Again, that's when they're trying to claim that my petition wasn't
Mm-hmm.
sufficiently pled.
and
I mean,
are they
I,
not prejudiced because they can postpone? Like there's no harm in postponing.
yeah,
Is
there's
that
no
why they're
harm.
not prejudiced?
And
Okay, okay,
yeah,
yeah,
and I mean, having to re-prepare for something isn't prejudicial to them.
gotcha.
What would be prejudicial maybe is if they couldn't get their witness there a different day, but then you would just schedule in accordance with the witnesses. Yeah, I mean, I think that if you can show that you've been working on the case, they'll give you the continuance. It's definitely not best practices to ask the day of,
Mm-hmm.
but I have, and I've been granted it, or a couple weeks beforehand. I think what people need to be careful of is they still have to file their trial memo and their response in anticipation of it not being granted. But anyway, I just think
Yeah.
just say that it's liberally granted, and
Okay.
hopefully people don't.
Yeah, and you
So
absolutely want to amend or make every effort as opposed to potentially saying, you didn't give notice, you didn't plead. The issues for me, when you raise the question, Jordan, and there's a variety of reasons why I amend. Often because I am learning things. So the UTCR says 120 days to file an amended. And the courts that certainly do a lot of PCRs, they understand setting these out and postponing these. But nevertheless, I like to get a petition filed in somewhat of a timely manner, but that doesn't mean I have all my discovery done. And then the way the ORCPs are and the way the code pleading is in Oregon, they can fight you on discovery if it's not specific to your claims. It's, without the federal rules that allow more general notice plea, and even other states I've practiced, you don't encounter these issues of discovery. They can actually say, well, this discovery you're seeking doesn't match your claim, so it's not specific. So I'm always mindful in what my claims are. Is, am I going to have to fight discovery, especially with third parties, but the state as well. So my amendments are, I'm trying to make sure that what I have in my pleading is going to support any discovery fights I need to have. But then also, when I'm learning new information, new claims, or even, did I not include something initially? Sometimes it's, okay, I didn't include something on the appeal that I should have because I wasn't as focused on the appeal when the first amendment came in, or whatever it may be. But it's both including every possible claim, and also was I specific enough, or even my theory has changed through the discovery I'm doing, and trying to be more specific. So both in terms of the discovery, if I'm going to have to go in and fight about discovery, and also specificity of what the actual claim is. It starts out as a Brady claim, but it gets more and more narrow of what actually happened in the state. I'm trying to be specific in the pleading, not overly specific. I try to make general claims, but what was a Brady claim might narrow down to something else, if that makes sense.
I think so.
Yeah, there's a lot of reasons why people amend. You might not, if you plead an expert, then, and they ask for the expert's report, even if you're not going to use it, then, technically you're required to turn it over. So, sometimes you want to hire the expert, figure out what they're going to say before you plead the claim.
Okay.
Yeah. So anyways, there's lots of reasons to amend.
Yeah. So if we can spend a second or two on the formal petition.
Okay.
You get the client's initial petition and you're reading over it. What are you looking for to make sure that you can include in the formal petition that may or may not have been in the initial one?
Everything. I mean, sometimes you get
Okay.
I mean, you're looking at the transcript. You're looking for legal claims. I mean, I see the pro se petition as, I don't know what it is. It's I don't want to say it's meaningless, but it's not helpful in terms of what claims you'll actually raise. I mean, those claims are important to look into, whatever they've raised, but for the formal petition, you have to consider everything that you've gathered.
Okay.
Yeah, it's the pro se petition. They're never pleaded as actual claims that the rules would require. They're not on point. Basically, what I find I usually use it for is, once I've drafted my claims and everything there, I take a look back at that and go, is there anything maybe that isn't included here? And I try to use it as a checklist. Like, was there something maybe the client was trying to get at that isn't included here? But only in that way. I mean, they're pretty much just a mess in terms of trying to plead claims that conform with the rules. But certainly it is a go back to, okay, what was in the client's mind, or whoever was helping them at the time they did it, as a look back. But I don't use it for anything more than that.
Yeah, and they are a good jumping off point for your first conversation with your client, because from that from the pro se petition, then you can, begin explaining what a post-conviction is and what sorts of claims fall into a post-conviction, and talk about how your initial reading of their petition, some of these claims might not fit into the post-conviction framework, but you'll work to try and reframe their claims, reframe what's important to them to fit into the post-conviction framework. And you can really get a sense, I mean, the initial petition can be extremely useful because from that you understand your client. If they're doing it themselves, you understand their education level, their sophistication in terms of the law, and what's important to them, in their case. So it's very valuable, but not necessarily for your claims with a formal petition.
Gotcha. Okay. Is there anything else that we want to be sure that we've included in the section on asserting legal claims? So when we're talking about the filing.
I would say that more often than not, 9 times out of 10, it's improper to have legal citations in your petition.
Really?
Yeah.
The statute even says you can include a brief. There's a PCR statute that says you can include a brief, but don't argue law in there. I've used it on occasion with things that are just kind of very general, that if I cite this case, that's going to be noticed for a bunch of things. But yeah, I think both under the ORCPs and that PCR statute that says don't cite cases, it's not typically, it shouldn't be in there.
I mean, it's just not proper civil pleadings. Pleading is my understanding. I could be wrong, but it's like Brady you can cite, Strickland maybe, Ramos. But it's the skeleton of, I mean, all you're doing is giving the state notice of your claims, of the facts of your claims.
Mm-hmm.
I don't know, Ned, Ed, do you feel like it's too broad of a statement to say don't include legal authorities?
That might be.
That feels pretty
or
broad.
maybe even we just
broad.
cite the PCR statute that says, if you want to include
Okay.
a brief with legal authority, do that, because there are situations. I mean, I kind of thought I would never do that, but sometimes I do, because I go, by citing this one case, I can, say, I give you a whole bunch of notice of a whole bunch of things. So I don't want to say never, but I do think maybe helpful to. I mean, I agree with you. It's not good pleading form under the civil rules, but since the statute talks about filing a brief, rather than including that in your pleadings, that might be the best way to do it.
Mm-hmm. Okay.
Yeah, I'll dig up the statute, or if one of you has it readily in hand, if you could email me, we'll make sure it's got the.
I'm
got the
headed
correct
to my
language.
desk right now, so I can pull it up right now.
Oh, great.
Move on to the next thing, and I'll grab that.
While Ed grabs that, anything else we want to talk about in the pleadings section?
I mean, it sounds like Ed and I have different ways we plead claims. So I don't know how. I think your last bullet point, that the purpose is to give the state notice of the facts of your claims, is probably sufficient.
Okay.
I don't know how many people are running into the same issues I have with the state being upset how things are pled. I mean, my experience, the state is really falling back into the actual rules of civil procedure to try and bar some really strong claims. which I have my own opinions about that. So I don't know. I think it's just something that people have to figure out. And we did
I see them trying to do that, Ginger, with the court trying to get into this technical pleading thing, and the courts not really knowing. I mean, they brought it up at trial, and the judge said, okay, well, we're going to postpone this, and I'm going to let him amend his pleading. And it was like a 4-year-old case. I'm the 5th lawyer on, and they backed down because, and I was like, Judge, their argument they're making is ridiculous. Like, you know, and she was like, they kept pushing it, and she said that. So they're doing that. And I just had them tell me they're going to move for a more definite statement in one. So it's definitely something going on over there. And that's why even more so, I think with the mind towards discovery and the mind toward these games, I think we do really need to be on point how we're doing it. I don't know that more specificity is the answer, like you said. I look at the way I plead other types of cases, and I think it's more general and broad, but there's definitely like an art there, right?
Yeah, and we just don't want that's a problem. We don't want a bad ruling on it, even though I'm 99% sure that we would have, that we would prevail on, and they have to move for more definite and certain much earlier than they are. But at any rate, I think that they are trying to bar legitimate claims. So, not based on the merits of the claim, but based on the rules of civil procedure, which is why post-conviction attorneys really need to be on top of civil procedure. So I guess we just emphasize that.
Stick that note up here. Okay. Right. I think that is a pretty good place to stop for today. For next time, we'll have litigating claims, which will cover motions practice and the trial, and then obligations after trial, which I suspect will be perhaps brief.
In the litigating claims, we need to talk about the trial memo and the response to the defendant's trial memo and objections to exhibits.
All right, well, I will tag.
Yeah, I would just change the heading up top where you have amended and then in parentheses formal, because it is a formal petition. It's not referred to as an amended petition. And maybe have the amended in the parens. Amended pro se.
Maybe.
Something, I don't know.
Find these little carrot things when I need them.
So I have a call at 1 o'clock. So I'm depending on how long it goes, I might pop into the habeas, but I'll definitely not be there at 1.
Perfect. All right, so that gives us our order.
138 ORS 138 580. Jordan, if you look at the last sentence of that long paragraph, that's what we're trying to capture as far as whether you're going to cite legal authority.
You said 138 580.
Yes.
Last sentence of the first paragraph. Great.
I don't know if it's helpful at all, but I mean, you probably have tons of case numbers that you could look at, but if you wanted to kind of look at how a case progresses and like an amended petition, versus a pro se or a formal petition versus a pro se petition, I'll give you the case number to a case that has a lot of experts, it just has a lot of information. If I don't know, is that helpful at all to kind of look at the pleadings?
Why don't you email that to me,
Okay.
and that way
Yeah.
we've got
I'll,
it
s-
written
I'll
down as
send you this
opposed to.
case number so you can kind of just see what it looks like.
Thanks. And if you could include Colin in that also,
Oh, sure. Yeah.
he's going to be the one ultimately writing these.
Okay.
All right, so I'm going to stop our window sharing. Ginger, have a good 1 o'clock meeting. I hope
Oh,
it's brief
thank you.
because we'll miss you. And Ed, I'll see you in a few minutes at the habeas meeting.
Thanks, Ginger. Thanks, Jordan.
Yep. See you. Bye.
Thank you both.